Hello, and welcome to today's webinar. My name is Daniel Castro. I'm Vice President of the Information Technology and Innovation Foundation. ITIF is a Washington, D.C. based think tank focused on the intersection of technology and public policy. Today, we're going to be talking about encryption. Encryption is crucial for protecting the privacy and security of data and communications. However, for nearly the last 3 decades, encryption advocates have been at odds with law enforcement. Law enforcement often argues that encryption undermines their ability to prevent and investigate crimes. And over the years, we've seen the US government take a number of steps to subvert commercial use of encryption, from imposing export controls to limiting dissemination of academic research to even at times secretly modifying technical standards. And more recently, this debate has mostly been a war of words. But what we're seeing now is that there's growing congressional interest in passing legislation that would effectively ban what law enforcement calls warrant-proof encryption. And specifically, this type of legislation would likely prohibit companies from offering features like end-to-end encryption that's used on messaging and which are growing in popularity and use globally. So this is a very important issue that has broad implications for many different people and businesses. Joining us for this conversation today are 3 experts on the topic. I'm delighted that can join us. Rihanna Pfefferkorn, Associate Director of Surveillance and Cybersecurity at the Stanford Center for Internet and Society. Hannah Quay de la Valle, Senior Technologist at the Center for Democracy and Technology. And Nemas Giuliani, Senior Legislative Counsel at the ACLU. All of you for joining us today. To kick us off, I just want to start with maybe a basic question. Rihanna, maybe you can take this first, and then I'll open it up to both Hannah and Nema. Why is encryption important? Why is this such an issue?
Well, encryption is the best way that we know of right now to be able to protect the confidentiality, integrity, and availability and privacy and security, basically, of our communications and our data. It has become an issue, I think, more at the forefront and come up again in the recent years because of the increasing use of encryption to protect our web traffic, to protect our devices, to protect the communications that we communicate over messaging apps, as you mentioned. Whereas previously, a lot of that information was not yet encrypted. We are in a better position now because of encryption being more ubiquitous than we were back in the 90s or back in the 70s, when encryption was largely limited to financial and military government applications. This is the technology that helps secure your banking, your e-commerce, your conversations with people on the other side of the world, especially right now when none of us can really go and meet face to face in order to have the kinds of private conversations that we might be used to having, and it's what shields all of the data that is held about us, both by private companies and by governments alike. And so the importance of it, I think, is hard to overstate. Particularly in a country like the United States, where we have built a society that is much more digitized and much more heavily dependent upon electronic information, electronic databases than some other countries are. So the importance of encryption really permeates everything from national security to our economic interests, and in addition to just each individual person's privacy and security of their data and communications.
Thanks. And Hannah and Nema, would you like to weigh in?
Sure. I mean, the only thing I'll add to that, which I think is exactly right, encryption is a part of, pretty much almost everything we do, whether it's banking or schooling or even accessing healthcare, is I think in, the modern world, there's increasingly a connection between, access to encryption and, civil rights like your First Amendment rights. If we look at, for example, the most recent protests, what we saw was a lot of protesters, many of whom are historically from communities that have been targeted by surveillance, really rely on encryption to organize protests, to communicate with other people. Abroad, where there are human rights activists and others who are targeted by repressive governments, often encryption is something that people rely on as a way of organizing and combating repressive regimes. The State Department in the past has even invested in trying to get activists and others access to encrypted technology so that they could avoid some of the consequences of having their private communications or information leaked to other actors. And so, it's not just about kind of the everyday practicalities. I do think that it's connected with the ability of people to exercise their rights and, most significantly, their First Amendment rights.
Yeah, I think that's all right. The only thing that I would add is that, which Brianna mentioned, but I think it bears repeating, is that security on the internet is just hard. It's very complicated, and encryption is hands down the best technology we have to do that. It is, yeah.
So, oh, please continue. Hannah, let me stay with you for a minute. I mean, I think what's interesting is that the argument from law enforcement is that they would agree so many things are moving online, and that's why they want to have access to more of this data. That traditionally, in the past, crimes were committed in an offline world. They could go in and get a search warrant for whatever they wanted. Now everything is happening in the digital world. Why can't they get access to that kind of information communications now? Do you see additional concerns that they have there, and how legitimate is this type of question that they're having?
I obviously have a particular position. I don't think that that's particularly legitimate. I think, for starters, they like to say that they're going dark, and one of my old colleague Joe Hall used to say that's because they're used to staring at the sun. The sort of digital revolution gave them incredible access into people's lives, right? In the sense that we build data trails, I mean paper trails, but digital paper trails at a kind of astounding rate, given the pervasiveness of technology in our lives. So to say that like they're being denied access to something that's fairly new and fairly extensive, I think is a little bit, I don't think that necessarily holds a lot of water.
Yeah. Nema?
I mean, I think that we should really approach those arguments with a high degree of skepticism, given the history of this issue and the FBI. We've never been able to get accurate statistics out of the FBI, right? I think, testimony that, Director Wray and others had put out there have been disproven, and the IG has said that those numbers were actually improper, and they've admitted that there were errors in some of the initial data they put out there. We haven't seen an analysis of not even the number of cases where encryption is even implicated, but moreover, whether there are other things that could help fill any investigative gaps that exist. And then I think thirdly, we're having a broader conversation at a national level over what public safety means and whether we should really be investing in law enforcement versus other mechanisms to address public safety issues. And so, I am very skeptical of the argument, not just for the reasons Hannah outlined, but for the fact that we actually haven't been able to get accurate information out of the agencies who claim that, essentially breaking the security of everybody's devices is critical to combat crime.
Yeah. And Rihanna, maybe you can expand on that last point as well, because I think that's where there's kind of the central question of, law enforcement is making the argument, as I understand it, that exactly to what you just said, that, that they would view it as, well, shouldn't we all sacrifice a little security for, this collective benefit of having stronger policing capabilities? And so there's a really important question here of understanding, well, how much are we losing and how much are they gaining?
I mean, I agree that I think everywhere in this debate, it's trade-offs all the way down. And to build on what Nema was saying, I think that law enforcement, in terms of their outlook on this issue, has one particular set of equities that they are considering, and they are not necessarily approaching the question from fuller cognizance of all of the other equities that come into play in terms of free expression, in terms of the needs of human rights, in terms of privacy, in terms of prevention of crime, as Nema was saying, in terms of keeping the need from investigations from happening in the first place. And I think we're seeing a shift now towards thinking about, if we were to reimagine what criminal justice and public safety look like, then perhaps we could expand in what our view is of what that would be. So when it comes to sort of that trade-offs question, I think that there is a tendency to underestimate the costs and overestimate the benefits, not least because, as Hannah was mentioning, there are so many other sources of data available in what has been called our golden age of surveillance to investigators that it's not really clear, and going back to what Nema was saying about the amount of data we don't have, what exactly the marginal impact is of encryption on law enforcement's investigations. We just don't have any clear numbers about that. On the flip side, I think that there is not necessarily a complete picture of what the benefits are that encryption adds in terms of protecting the economy, in terms of preventing crimes from happening. And it's hard to quantify harms that have not happened. So it becomes difficult to say, here are the harms that we have avoided, and we already don't have good data to say, and here is the impact marginally on investigations that make them not impossible. I think we have comprehensively now addressed the idea that it's impossible to investigate, but at least adding some friction in there. And when it comes to the expected upside, and I'm kind of rambling now, sorry for this, but the expected upside I think may be more modest than is believed, because it's never going to be a 100% solution. And there has been really varying willingness on the part of top law enforcement officials in the federal agencies to acknowledge that. Sometimes we've seen some officials have said so, and others have not acknowledged that it is always going to be, you will get some some data for some people, but given that encryption technology is a cat that's out of the bag now, it's always going to be available, and therefore for motivated and sophisticated criminals, they will be able to shield their data and their communications, and so it is not going to be 100% solution, even if we were to include a backdoor mandate that, as Nema said, would affect 100% of users.
Mm-hmm. I thought it was interesting, as you said, Brianna, it's trade-offs kind of all the way down. The other thing that's very common in policy and policy making is symbols and imagery. And one of the things that is striking to me about this debate on encryption is that we've seen a shift in the argument from we need to put backdoors or restrict end-to-end encryption to address crime, but specifically terrorism, to more recently a shift on protecting child safety or combating child sexual abuse imagery. And so my question to that, and maybe Hannah, I can go to you again, because I know CDT has been involved in a lot of these debates. What do you make of this recent emphasis on the threat of end-to-end encryption to law enforcement's ability to police child sexual abuse materials? Because that, to me, when you look at the recent tech debates, that's an issue that has gotten legislators to take action, whereas in the past, maybe they were more willing to strike a balance, but nobody wants to say, well, we want to trade a little bit of encryption and not protect children. So how do we balance that part of it?
I think this sort of goes back to, again, what Nema was saying about, I think that we are focusing a lot on how do we find these people once the crimes have been committed, right? And that doesn't help us with how do we prevent these things, right? And I think expending this kind of energy on dismantling a safety technology essentially draws resources, draws expertise, draws time away from focusing on other sorts of ways to be addressing this problem, right? And I'd highlight that Wyden actually introduced a bill recently that proposes other ways to start dealing with the problem of child exploitation online. And it's things like, better oversight of how law enforcement agencies are handling that and ensuring that they have the resources to actually prosecute those crimes when they find them, because that doesn't always happen either. So I think that there are people and legislators presenting solutions that would help start addressing this really horrible problem of child abuse online without dismantling a safety technology that protects people online. Does that answer you?
Yes, thanks. And Nema, I want to ask you to weigh in as well. I mean, ACLU obviously has a rich history of always defending civil liberties, right? Kind of regardless of these trade-offs, but I would expect these trade-off questions come up in the advocacy work that the organization might do.
Sure. I mean, I think that when it comes to the encryption issue, what we've seen as sort of a common technique is a focal point on crimes that are particularly bad as a justification for the encryption proposals. We saw this with San Bernardino, where there was efforts to force Apple to decrypt an iPhone and unlock an iPhone. We're seeing it now where I think, childhood exploitation, which is a very real problem, is sort of being used as a focal point for encryption. And to justify this idea of backdoors. And I think that for me, what is frustrating about this is, while we're having this debate, there are a multitude of things that Congress could do that wouldn't affect the security of everyday devices that would actually address the problem of childhood exploitation. Expansion of T and U visas and other methods so that victims of crime can come forward. Actually providing, mental health services to address and try to, prevent abuse on the front end. Addressing questions around allocation of resources and whether we have the resources to not just treat, but also to respond and investigate claims of child abuse. All of these things are, things that have been put forward. They point to deficiencies that many have highlighted as existing problems that have not been addressed for years. And instead of actually focusing on those solutions, I think, there's sort of this bait and switch and this suggestion that encryption is going to fix the problem when, or having a backdoor is going to fix the problem when, it won't at all. And it comes with all of these downsides, including, domestic abuse survivors, many who also rely on encryption as a way of safeguarding themselves from abusers. So, I have to say, I find the solutions around addressing these problems frustrating because there are very obvious things that need to be invested in that are not.
Thanks. And kind of extending on that, so at the last major congressional hearing on this topic, the one in December with the Senate Judiciary Committee, Senator Graham told industry, very clearly that if they didn't find a solution to law enforcement's problem, Congress was going to be stepping in. And obviously, we have this new bill that we'll talk about in a moment that is kind of him making good on that promise. But I guess the question I have for you right now is, and Rihanna, maybe I can start with you on this. What do you think tech companies can do to respond to law enforcement's concerns, or are there things they can do? Neema just outlined a lot of things the government can do. Is there anything that industry can start on?
So I think that with respect, especially to the question of child exploitation online, that companies are in a tricky position here in terms of explaining what they are doing, because there's already a lot that many major providers do in order to detect and get rid of this kind of content on their services. They run automated scans, they send those reports off to the National Center for Missing and Exploited Children, as they are mandated by federal criminal law to do, and they do so millions of times a year. So that's sort of the obvious way that is publicly known, although the underlying way that the technology works, that's called photo DNA, is still a closely held secret. And the reason for that is because you don't want to give wrongdoers a way, a roadmap basically to circumventing the measures, whether it's photo DNA or other measures that these providers take in order to cut down on this content on their services. This is a pernicious problem that has been around ever since there was ever first a capability to very slowly send any kind of content from one person to another. It's inherent to the internet that if you are going to enable people to communicate with each other and to share content with each other or to upload and store it, then there's going to be bad kinds of content as well as good. And so the measures that, especially the larger providers that have the resources to really dedicate to fighting this problem, the measures that they have taken necessarily are, not necessarily well publicly understood. And my worry coming out of the December hearing, and this has been backed up by the bills that we are going to discuss, was that it may be already sort of too little too late for companies to be going, and at least behind closed doors, if there are quiet ways that they can talk to congressional staff to explain, here are some of the things that we are doing with other information besides access to the content of communications or private DMs or access to stored emails or what have you, in order to fight this, because there is such a panoply of data available. Our entire social graphs in terms of whom we email, who are we connected to on various social media platforms, other signals that you can use in terms of, we believe that this user's inferred age is 40 something and this user's inferred age is 15. If those two people are connected, are having initiating conversation, maybe there's something amiss there. So there are all these things that platforms can do, and that includes even building in more robust reporting of abuse requirements, or tools rather, into even end-to-end encrypted apps, some of which are public or easy to sort of guess at, and some of which are necessarily going to be held more closely in order to prevent abuse of those anti-abuse mechanisms. So I think that, as said, providers are in a tricky position. It may be that the time window has already passed where they can coherently and persuasively tell members of, especially the Senate, that they are doing what they can already to fight this problem, whether it's especially child sex abuse material, but other types of offenses as well, without sort of giving away the game.
If no one has anything else to weigh in on that, maybe I'll move to another question. You know, one of the other things we've heard a lot from senior law enforcement officials, including, you know, Attorney General Barr, but also, you know, some of the past FBI directors, is that they've said, you know, that advocates of encryption are misrepresenting their position, that they don't want a back door, they want a front door. And so I want to ask what distinction you think they're making in that terminology, and, you know, as a technical matter, you know, does this matter?
I mean, cynically, I think the distinction is that they think that front door sounds better than back door, right? Like, those two terms they're not meaningful. There's not a meaningful distinction between them. It's a question of they want a dedicated way to access technology. And there's not, I think, a meaningful technical difference between those two things either, right? Either, like, however you want to describe it, what you're saying is you want a way for some third party, presumably only law enforcement, to have access to what would otherwise be encrypted data. And I think that's, you know, we've seen that come under a number of different names: front door, back door, exceptional access, golden key. Like, they're all sort of iterations of the same deal. And the naming, the renaming doesn't get you around the fact that adding some sort of exceptional access technology will weaken the overall security of the system. And it's an incredible oversimplification to say that it will be very easy to make sure only law enforcement has access to it. That's just not a guarantee that you can make.
And Rana, maybe I can go to you on the next question. I mean, following up on that, you know, I think a lot of law enforcement officials, you know, what they say in their speeches is that, well, you know, if, you know, X or Y online service can do key backup methods, or they're already using key escrow for a particular service, isn't this evidence that it can be done in a secure and reasonable manner? How do you respond to that type of critique?
I mean, so I guess the responses are kind of, you know, number one, it's not as though there is no risk entailed in the methods that we already have, such as the ones that you mentioned. If you create, you know, the kinds of mechanisms that you're describing, there's still a lot of data and, you know, that kind of access mechanism that will need to be very carefully guarded by all of the players in it. And this is something that is not necessarily going to be feasible, especially for smaller fires. Let's say if there's a small handset manufacturer in Taiwan, it's not going to have the same resources to protect a key escrow mechanism as Apple would, for example. Another is that a lot of the examples that law enforcement uses tend to come from highly regulated industries, especially the financial industry, where, for very good reasons, we do have regulations in place that say you do have to be able to log your chats. You have to have some mechanism for, basically, for investigators to go in later if financial regulators suspect that there's been some sort of market manipulation or antitrust offense or what have you, in order to go and root that out. But everybody's communications should not be held to the same standard as some highly regulated industry, whether it's finance or health or aerospace or what have you, because it's unreasonable to hold ordinary people's private communications to that same standard, because you don't have those countervailing interests in cutting down on abuse in the financial system or whatever to back that up. So I don't think that those comparisons are really that fruitful or helpful. It is simply not the same. It's not, you know, comparing two different apples. It's still sort of an apples and oranges question, in my view.
Yeah, I think it's really interesting that, if you look at the broader security debate, there's a lot of emphasis right now on moving to a zero trust architecture, which is assuming that you can't trust what's inside your network, which is kind of the opposite argument of what law enforcement is saying here when they're saying, well, you can have this trusted third party. Nima, I wanted to go to you and ask about, the argument that law enforcement also makes around the Fourth Amendment, that they say the Fourth Amendment is about striking a balance between an individual's right to privacy and the government's right or ability to access. And there shouldn't be these kind of lawless zones, is what they usually call it, lawless zone where you can't access certain information without a warrant. Does the Fourth Amendment give government the right to regulate encryption?
Yes, the Fourth Amendment has never been a guarantee for the government to be able to access literally anything, right? And so I think that there's a misconception of if that's sort of the argument being put forward. I have one of the things I have heard people sort of emphasize, and this kind of goes a little bit to the front door, back door distinction is, well, we have a warrant. And if we have a warrant, we ought to be able to get this information. And I think there's really, two additional problems with that argument. One is what we're doing is we're shifting responsibility on the private sector to really build a government surveillance architecture. And that's pretty striking. There are Fifth Amendment limits on what the government can compel someone to do to assist with their investigation. But I think even more broadly, the idea that the government can conscript Apple and other companies to do something that they wouldn't normally do, that's not good for their customers, that's not in their own interest, to facilitate surveillance is sort of a really disturbing shift. I think the other problem with that warrant argument is, more broadly, it doesn't address the racial justice issues that are going to stem from an encryption backdoor. I mean, realistically, if there was such a backdoor based on biases in policing, that's a backdoor that's more likely to be used on certain demographics, like communities of color. If you look at, for example, even execution of warrants in the drug context in places like California, despite even in places where you might have similar rates of drug use among races, African Americans are overwhelmingly served with search warrants in disproportionate rates. And so, if we're having a broader conversation about how to make policing more equitable and how to address racial disparities, that warrant argument, it's better than no warrant, but it doesn't actually address that fundamental problem. And I think that that's something we have to factor in as we're thinking about, how to reform policing more broadly.
And can I just build upon that? One of the other problems that I have with but we have a warrant argument is that the Fourth Amendment warrant requirement is not all encompassing. We've had to fight it all the way up to the Supreme Court to protect your cell phone, to protect your historical cell site location data just in the last few years. There are so many exceptions and carve-outs in places where the Fourth Amendment just doesn't apply in the first place. So there would not necessarily be a warrant. And yet what law enforcement is asking for is to build in upfront the capability to give access to this data, which would still be there even if there were no warrant whatsoever. A good example is the battles being fought out in multiple courts of appeals over the ability of people to have their devices unlocked at the border for border agents before they may re-enter the country, either visitors to the US or US citizens. And we're starting to see, maybe some traction to the idea that maybe there ought to be a warrant and you shouldn't just have to open up your device because what are you going to be carrying, all of the contraband of a bundle of heroin inside of your phone? No. And so that's an example of where it is not clear that there is a warrant requirement. And yet we're looking at an example of if law enforcement were to have its way, those devices would be, everyone's device would have to be backdoored and openable by Border Patrol agents, even in the absence of a warrant. And given the number of people who cross the border every year, we're already talking about a significant potential number of people who might get their data snooped through at the border on absolutely less than the warrant standard that law enforcement keeps liking to tout.
So, as I mentioned at the outset, there's two laws that are under, or two bills that are under active consideration right now that could have an impact on encryption. The Lawful Access to Encrypted Data Act, that I don't even know if you're supposed to say it, LEAD or LAED Act, and then the Eliminating Abusive and Rampant Neglect of Interactive Technologies Act, more commonly known as the EARN-IT Act. So the first one is the one that would most directly addresses encryption. And Brianna, you wrote a whole detailed blog post on this. I know you've been thinking about the bill in some detail. So could you just maybe briefly outline, what the law requires and what its impact might be in both the short and long term?
So at the high level, this is the backdoor mandate that law enforcement has been calling for, but that previously we haven't seen anything this broad be introduced legislatively, at least at the federal level, in quite some time. It would modify the federal framework for the issuance of warrants and for the issuance of other kinds of surveillance orders, including orders for metadata as well as wiretap orders, to clarify something that has been a subject of legal battles in the courts in recent years over what the extent is of providers' duty to provide technical assistance to access to data for law enforcement. And it would clarify that, yes, you'd have to build in the capability to decrypt. And so once you are served with a technical assistance order in connection with a warrant, a wiretap order, an order for monitoring metadata, you would have to, as a provider, respond and provide that data in unencrypted form. And therefore, in order to have the capability to do that, even sort of medium-sized providers, meaning 1 million or more US customers in any given year, or monthly active users in the US for online services, would have to proactively redesign all of their systems in order to make their systems and the data decryptable in order to hand that over to law enforcement. In addition, for smaller providers, those who are not part of the million plus club, the bill as currently stands would allow the Attorney General to issue a directive to the provider saying you have to redesign and build in this capability. And then going forward, that capability would be in there. And the Attorney General can also issue directives saying you already have this capability, therefore you have to maintain that capability in order to give us access should we come back with one of these technical assistance orders. It has similar provisions that would amend FISA, which is the foreign intelligence side of the law, as opposed to the criminal side that sets forth the wiretap and metadata and warrant framework for ordinary criminal investigations. So that's kind of the high level overview of it. And what this would do would be to replace some of the court-developed law that we have seen around the extent to which, as Neema was talking about, providers can be compelled to assist in investigations. And it provides the clarity that I think law enforcement has hoped that they would get under existing law, but so far has not been able to obtain.
Yeah. Hannah, any reactions to the bills that have been introduced?
Sorry, my dog was barking. I think Rihanna gave a great overview of them. I think, the Late Act is clearly the more direct assault on encryption. I think the Earn It Act would probably similarly impact providers' ability or inclination to use encryption. I mean, it goes at it in a much more indirect way, but it still introduces substantial liability, and I mean that both sort of in the legal, but also just in the sort of technical sense of just there's a lot of reason to believe that it would make them more vulnerable in court should they build encrypted systems, even if that's not something that's specifically addressed in the bill itself, because they would have to fight out that argument sort of through the court system. So I think either one of these is essentially going to mean that it is the sort of cheaper and safer thing to do to construct your products in a way that they are available to law enforcement. And that would just be because you want to build a product that you're pretty sure is going to be stable over time. And if it seems like the bellwether is moving towards backdoors, it gives companies an incentive to just start building to the environment that they think that they're probably going to be in. You're still muted as well. Thanks.
My dog too was having some concerns. So I wanted to ask about the Earn It Act as well. On that bill specifically, to me it's interesting. They're trying to tie Section 230 to the encryption debate. I think again, partially because there's some momentum for reform in that area. So they're looking for potential momentum on an encryption bill. as well as, there, in the most recent revision of the Earn It Act, is my understanding, my read of the bill, is that, it would potentially allow states to end up setting the standard around encryption, because the states would be able to, enforce a provision in this new law that they couldn't enforce before, and they could basically make this determination about whether or not, for example, end-to-end encryption was a necessary practice the companies would have to undertake. And so I want to ask, and I'll open this up. Maybe Hannah, you can go first. I know you've looked at this, and anyone else who wants to weigh in. To what extent one should this kind of debate about encryption be tied to the debate around Section 230, and two, to what extent do we need a national framework for encryption versus a kind of a state by state, or letting states take the lead in this policy debate?
So to the first part, how should the two be tied together? My inclination is sort of no, in the sense that, they're quite separate issues, I would say. And I think tying them together was sort of more of a convenient sort of positioning, right? In the sense that there is a lot of momentum around 230, and it's not clear that there's quite as much momentum around encryption. Of course, the most recent version of the bill does introduce an amendment from Senator Leahy that actually does have an encryption carve out in it. Although even that then gets kind of complicated, because the bill used to give you a way to earn your 230 liability shield, hence the name. The new version of the bill doesn't actually have that anywhere in it. And so there's no way for a company to give themselves that early protection from lawsuits that 230 affords them, which means that even though that there is this encryption carve out in it, they're still, as I said, going to have to fight that out through a potentially fairly protracted court battle. So and then at the end, there's no guarantee necessarily that the encryption carve out would protect them, because the way it's worded, the scope of it may, they could very well get through the legal battle only to have the prosecution say sort of like, well, it's not the encryption itself that makes you liable, it's this other technology that you did or didn't build, like, client-side scanning, which many technologists like myself would sort of argue breaks the expected qualities of an encrypted system, even though it's not necessarily the sort of encryption itself. So you might still end up at the end of this court battle and find yourself on the hook, even though you expected to be able to use the defense of, well, our system is end-to-end encrypted. We couldn't see that the CSAM was there, and therefore we shouldn't be liable for this. That's not even really necessarily guaranteed. So the Earn It Act sort of entangles 230 and encryption together in a way that really means that it's very difficult to actually build any protection for encryption into the current version of the bill anyway. So yeah, I think that tying them together is more about political expediency than any sort of inherent connection between those two things.
Thank you. I want to ask as well, whenever these debates about encryption come up, one of the arguments that the industry usually makes is that this will have a direct impact on US tech companies and their ability to be competitive overseas. I want to ask maybe a couple questions in that vein. One, just as a starting place, what impact do you think, I'm going to call it the LEAD Act, even though that's not how it's spelled, the LEAD Act would have on the competitiveness of US companies? I'll open that to whoever wants to take it.
Yeah, I think that we are seeing concerns about the viability of US products and services in other markets in the event that US providers are forced to proactively insert backdoors into those products and services. This is already happening in connection with the tech sector in Australia. So at the end of 2018, Australia passed a law that seems to have provided a model for the LEAD Act, as we'll call it, maybe the awful Access to Encrypted Data Act instead of Lawful. But the Australia bill had similar, directives that can be served on providers in order to require them to build in a technical assistance capability. And the result of that has been to do a lot of harm to the tech sector in Australia. Microsoft has said that they have requests from their customers not to store data on servers in Australia for fear that one of their employees located there might be suborned into providing backdoor access to those customers' data. It has hurt homegrown Australian companies. So Atlassian, who has a significant Australia presence, has been very active in speaking out against this law and talking about the harm that it has done to their business there. So we're already seeing how this law kind of was a way of shooting themselves in the foot in what had previously been a really just going like gangbusters economy across the board in Australia. They're suffering the same way everybody else is globally due to the coronavirus shutdowns. But we have this example of the negative impact and how quick it was in part because this bill was so controversial and created such a lot of negative sentiment, even though it did ultimately pass. And so I think we could expect to see the same thing here, because why would anybody from other countries want to buy a product that they knew had a guaranteed US government backdoor built into it? We see a lot of the same pushback against Huawei on the same grounds that China can be expected to potentially require Huawei to build in backdoors so that the Chinese government can listen in on American communications and grab American data. And yet there seems to be blindness on the part of the same policymakers in Washington who are up in arms against Huawei that passing the LEAD Act bill would effectively require the same thing.
Yeah, I think the parallel there is really interesting. And speaks to the fact that it's a very important issue. I mean, whether you're talking about Europe, or Australia, else. Nima, I want to bring you in on this question as well. This question of how policies also in other countries. Rihanna mentioned the Australian one. There's also the UK surveillance bill. How is this shaping the global debate around encryption and kind of the expectation and norms about where civil liberties exist online?
Sure. I mean, I think it's important to really, emphasize that the position the US takes on this is going to have a huge global effect, right? The US is seen as a leader on this issue. And if the US puts in place a backdoor mandate, we're put in a position where we can't criticize other countries for doing the same thing, including in countries where everyday citizens rely on encryption to protect themselves from whether it's repressive governments or other harmful actors, right? Countries that have, concerning human rights records. And so, I do think that if you see the U.S. take this move, you will see, increased pushes around the world for similar types of backdoor mandates, which not only affect, I think, the commercial side of things, as Rihanna talked about, right? Like what person abroad wants to buy a U.S. ready, iPhone or U.S. tech product that's open for U.S. government access. I also think it's important to sort of underscore the human rights, implications of this. The UN Special Rapporteur has talked about kind of the importance of encryption and the importance of being able to communicate anonymously and how important encryption can be to, activists and dissidents abroad. And so there is a huge global effect from the decision that we make in the US here. And it's an effect that is not only going to affect sort of the economic outlook, but also going to affect, the types of moves we might see in regimes that already have concerning human rights records.
Thanks. So I want to let everyone who's watching know that you are welcome to ask questions online. If you're streaming on YouTube, there's a link in the description to Slido, which is our platform we use for taking questions. If you're on the ITIF.org website, the question form is just embedded under the video. You're welcome to submit questions there. You can also vote on the questions that you want to have asked. I'm going to go to those audience questions in 1 minute. The last question I had that I just wanted to end with here is this question of, is there room for compromise? A lot of policymaking is about compromise. Do you see middle ground between law enforcement and what encryption advocates want? And Hannah, maybe we can start with you.
Yeah, so I think it depends on what you're going to call a compromise, right? I think that one of the, one of the arguments that has often been advanced by law enforcement is that the security community tends to be a little rigid about this, in the sense that they're like, there's no way to put in a backdoor that is a sort of no bus, nobody but us backdoor. And the reality is, like, that's true. So I think the compromise, to the extent that there could be one, needs to come from some of the things we were talking about much earlier in this panel about finding other ways to work with tech companies about how to build their systems in such a way that they are that they have capabilities to manage abuse better, that also can coexist with end-to-end encrypted systems, right? And Rihanna mentioned some of these earlier, right? Better reporting infrastructures for people who are already in an end-to-end encrypted chat. Better ways, signalings of analyzing metadata to try to find interactions that we find concerning. So I think that compromise needs to come from sort of broadening our idea of what it means to tackle this issue.
I'd like to add that I think we already do have a state of compromise in a lot of senses, in that there are companies that may provide end-to-end encryption or device encryption for one part of the umbrella of products and services they have, but are still able to provide access to data through another part. Even if my iPhone is encrypted in a way that can't be unlocked for law enforcement, iCloud backups can be produced to law enforcement. Your mail, if you use Apple Mail, can be. So even if there's device encryption on your iPhone, and even if there's end-to-end encryption on iMessage, there are still ways for law enforcement to obtain quite a lot of data that might otherwise be on that locked phone. And I think we see that not only within companies such as Apple, but across different products and services. So cloud storage is not typically end-to-end encrypted, neither is email. There's still a lot of data that is out there that is still going to be available to law enforcement under the current, uneasy status that we have, where we have not encrypted everything, even though there's more and more of a move to encrypt stuff like web traffic.
Thanks for that. So I want to go to the audience questions. We have a number that have come in, and you're still welcome to submit them if you're watching. The first one that I'm going to go to, and Rihanna, maybe we can start with you on this one. The questioner asks, so backdoors are bad. Aren't software/firmware update capabilities the same thing, backdoors to devices and software? Why are those types of backdoors okay?
This is another thing that law enforcement, I think, likes to use as a rationale for saying, we should be able to insert backdoors into everybody's devices. But the point of updates for, say, a mobile operating system, for example, or a version of an app, is that they are much rarer. There is a small number of people who have access to them. They are not frequently deployed. And that cuts down on the opportunity for mischief. Whereas if you had a backdoor and you had the keys in the hands of the provider, given that there are, 13,000 law enforcement agencies in the United States alone, and given that they would have to comply with demands from other law enforcement agencies around the world as well, we would be talking about accessing that mechanism much more frequently, 24/7, around the clock, thousands of times a year. And for every one of those things, the staff that you'd have to be able to respond timely to those kinds of requests at that volume, every additional person, every additional access, there's opportunity for a mistake to be introduced, or for somebody to be paid off to open a device, or for there just to be mistakes in terms of reviewing what could even be a falsified court order. There's already some precedent for that, even in the content takedown sphere. So I think it's still, while the point is well taken, the kind of number of access and volume and frequency of access that we would be seeing for access to devices or to accounts is really totally different in scope, and introduces a number of different risks that are not necessarily present on the relatively rare occasions that updates are pushed out to software.
Thanks for that. So a second question, Nema, maybe you can take this one. The questioner asks, does law enforcement have other ways to investigate online crimes that don't require them to access encrypted communications, and are these methods effective?
Sure. So, I mean, there's lots of, traditional investigative techniques that have nothing to do with, decrypting communications or accessing online communications. The techniques that law enforcement have used for years, whether it's interviewing, witnesses or suspects or relying on sort of other pieces of information. I also just think that, as Rihanna and others have pointed out, there's a wealth of information that is available to law enforcement that doesn't require any type of decryption or encryption backdoor. I mean, some people have called this kind of the golden age of surveillance because, quite frankly, there are records of things we have today that we never had 15 years ago or 20 years ago. I mean, just think of, a record of everywhere you've been and, what application you might have used or what you might have searched, on the internet. None of that was available 20, 30 years ago. So I think the idea that we have less information available today is really not reflective of the reality.
Thanks for that. Nema, maybe I can start on you for one more question here. Someone asked, what impact would banning the use of legal wiretaps, listening devices, or other technological listening tools have on fighting crime, including terrorism?
So, I think that there's, when we're talking about the encryption debate, I think often we're talking about something that goes far beyond your, historical traditional wiretap on a landline, right? We're talking about something that would implicate a multitude of tools, everything from a messaging services to the types of techniques that are used for financial services, et cetera. And so I think, as Rihanna has talked about, we're talking about an enormous downside and a trade-off. One, in terms of security and the cybersecurity implications. Two, in terms of the First Amendment implications and the ability of people to communicate anonymously and securely. And so, I don't think it's, a question of, I don't think it's just a question of what might be potential law enforcement needs, which we still don't understand and we still don't have a clear sense from, certainly federally and at a state level. So I guess, I don't know if that's the direct answer, but I think that's one way to sort of think about that question.
Thanks. Hannah, I want to turn to you for this next pair of questions. Someone writes, should law enforcement be banned from legally accessing under Fourth Amendment protections all encrypted information? And then related, if law enforcement should be legally allowed to access encrypted information, how should that be achieved?
So those are kind of interesting questions in the sense that I'm not, barring law enforcement access from encrypted information basically just means leaving it encrypted. So kind of the second that it is unencrypted, then the second that law enforcement has access to it, it's like necessarily unencrypted, right? So I certainly don't know what the sort of Fourth Amendment implications would be in that context. And perhaps one of the lawyers on the call would be better positioned to answer that. As far as like, if they should have access, how should that be implemented? I mean, I think that is kind of the question the debate we've been having all along, right? Is there a way to build in a purpose-built decryption capability that won't be subject to the abuses that we've been talking about? And, lots of cryptographers, lots of tech companies have thrown a lot of hours at that. And the answer is sort of no, not really, right? So I think that sort of, the phrasing of that question is a very nice distillation of the sort of fundamental issue we're accessing here, which is just, should there essentially be no places in the world that are outside the reach of law enforcement, right? And that's kind of an ideological question. And I tend to fall on the side of like, no, I think that people should and always have had the right to communicate securely outside of the listening ears of their government.
So there's a somewhat related question here as well. And I'll open this to whoever wants to take it. The question is, would the sale of hacking tools or backdoor encryption keys to the general public put our privacy or security at risk? And I guess the kind of follow-up question to that would be, how should that be regulated or managed by government?
So I think certainly the increased reliance on hacking is something that does pose a privacy and security risk. I think from a government end, one of the concerns I have is that, we know that agencies are relying on sort of hacking techniques, the FBI and others, And we really like run forward with this without any legislation from Congress, any more broad, widespread debate on what the cybersecurity implications are. Often for the government to hack effectively, they may sit on vulnerabilities and not disclose those vulnerabilities so that they can be fixed, which has broader cybersecurity implications for other individuals who might be using those same tools. And so, you know, I think this kind of relates to a broader concern that exists with the use of technology by law enforcement, which is that I think sometimes we're rushing forward with using new technologies, and we're doing so without legislative authorization and without a public debate about whether those are tools we want to be using at all. And so I'm pretty concerned, I think, about, you know, the fact that government agencies are moving forward when we don't have an infrastructure and a framework to even discuss whether those are things we should be doing.
Another question we have coming in, if we don't ban end-to-end encryption, what's the downside of this? Will less crime be prevented or be solved? How can this downside be measured accurately? I think we've touched on this a little bit, but I want to see if anyone else wants to weigh in on this.
I mean, we've talked a little bit about this in terms of, you know, to be clear, like, I don't think a ban on end-to-end encryption is called for. I think it's a terrible idea, and I don't think it would be effective. It will predictably have some, and already is having some, marginal impact on law enforcement's ability to investigate. And I think that some of the responses include, rather than just going after a technology that is a protective technology that protects security, that protects privacy, that protects freedom of expression, there does need to be more focus on sort of adaptation. I think there has been a lot of effort spent on the law enforcement side in lobbying and advocating against encryption, rather than focusing on adapting to the world that we live in now. And we're seeing, as Nema mentioned, the use of hacking tools, for example, and the springing up of third-party vendors to either provide their services or sell their solutions to law enforcement in order to get into iPhones, for example, which is now pretty regularly, law enforcement seems to have the ability to do so. I think that there just needs to be a lot more investment, not only in saying, well, what are the other tools in the toolbox that can be brought to bear, but also, as we've been discussing as a theme throughout this hour, how can we put more effort into preventative measures so that crime does not occur in the first place? And that looks like rebuilding the social support net that has been destroyed over recent decades, and expanding the, you know, the fruits of the promise of equal justice and equal treatment under the law to include more communities than it currently does.
So there's a question here which I thought was interesting, and it'll probably be our last question. And the person poses the question: say we ban end-to-end encryption, what type of transparency should there be around the use of such surveillance, and what safeguards should there be used for the same? I think it's an interesting question because, as we saw with Australia, things can change overnight. And so, you know, let's say Congress were to move forward with something like this, which I think everyone on the panel agreed would be a bad idea. Are there any mitigating measures that should be in place or would be necessary to put in place to have a better understanding of what's happening?
Yeah, I mean, I think that the measures that you'd want in place are things that our law enforcement agencies are already sort of falling down on the job on, as Nema mentioned earlier, right? Like, we already have situations where we haven't gotten we've gotten wrong numbers from the FBI about, you know, what kind of cases they are encountering issues with encryption. You know, in those cases, what other investigatory techniques were tried. And, you know, the argument is always made like, well, you know, it's not, we have a security reason to protect that, right? That's by giving that information, we're providing bad actors, criminals, with sort of a roadmap into like how we do our investigations, going to make it easier to dodge. But, you know, that also means that we then have law enforcement with exceptional capabilities and no oversight, right? So I think it's a little bit hard to talk about what kind of oversight we would want if we did ban end-to-end encryption when we already don't have the oversight that I would say that we need over our law enforcement agencies anyway. So like, let's get that in order before we start talking about providing more capability with, you know, maybe the same terrible oversight. Like,
Nima, any final thoughts on that?
Yeah, I mean, I would just echo that. I mean, I think that there are serious questions about the resources being used today and how they're being used and whether it's actually, in the interest of, public safety for all communities. And the idea that we're going to funnel more money and more, authorities to law enforcement, especially when I think here there are clear downsides. I mean, if we're talking about oversight, how will we measure the effect of a backdoor? How will we measure the number of people who don't go to a protest or can't organize a protest because they don't have secure communications? How will we measure the number of people who may have been the victims of identity theft or hacking, or because their devices are not secure? How do we measure the number of contracts that U.S. businesses don't get because fundamentally their products are less secure than their competitors? So, for some of those, we don't even have the data that Hannah talked about that we need. But I think measuring the overall impact is going to be challenging, and it is something that we certainly have to take into consideration when we balance the equities in this debate.
Great. Well, we're right at 4 o'clock. We're going to stop there. I want to thank each of you for joining us today on this really important conversation. Your insights were very much appreciated and welcome. And I should also mention ITIF put out a report today around encryption and the kind of history of some of the law enforcement efforts to subvert this, and why banning isn't the right answer in this case. So again, thanks to all of you for joining us, and we look forward to continuing this conversation.